Welcome to the Business SOS podcast. This is Rich Sierra, president of the Florida Small Business Legal Center. This is episode 139 of our podcast, and as we continue our road to episode 200. So I'm sure I'll have a celebration by then. So we'll continue our conversation with Matthew Fornaro as a friend and colleague. He's also another business litigation attorney in South Florida. He's also a mediator and an arbitrator. Our last episode, we went in great depth into mediation process. We talked about mediation. So in this segment, what I want to talk about is arbitration. Matthew, welcome to the show.
Thank you for having me, Rich. Glad to be here.
Right. So let's talk about arbitration. I've touched upon it at some other episodes, but not in great depth. So let's talk about what is arbitration.
Sure. So arbitration is a form of alternative dispute resolution. We previously discussed mediation. So mediation is not arbitration. Arbitration is essentially you have, instead of going to court, you have a private arbitration. It's usually in a private forum. It's not a public forum, where you have an independent arbitrator who, instead of a mediator where they don't make findings of fact, conclusion of law, the arbitrator does make findings of fact and conclusion of law. So you have an arbitration process, which is kind of like a streamlined version of going to court, but it's like private court. So you have an arbitrator who makes decisions just like a judge. They make findings of fact, conclusions of law, and ultimately they will hear the case and write an arbitration award, which is like a judgment that says who, what, when, where, why, and how about the case, who gets what, and, signs it, and then it's an award. So how do we get to that process? Well, let's start out. So arbitration can happen in a number of ways, okay? You have to agree to go to arbitration for the most part, although I'll talk about some exceptions to that. So a lot of contracts that consumers sign, a lot of contracts out there have arbitration provisions in them because they don't want you to go to court. They want you to go to arbitration. So arbitration is governed by either, like an ad hoc thing where it's governed by the state law that you're in, the State Arbitration Act. It's governed by the Federal Arbitration Act, or it's governed by the arbitration agency that you've agreed to in your contract for your arbitration purposes. So there are, for general disputes, there's three main arbitration companies out there. There's the AAA, which is the American Arbitration Association. There's JAMS, and then there's NAM, which is the third one. And then there's specialized arbitration companies out there that deal only with special issues. So like there's FINRA and there's the NFA, and those deal with special issues in a limited, jurisdiction and scope. Okay. So FINRA deals with like financial regulatory things. So like stocks, investments, things like that. That's FINRA arbitration. NFA is National Futures Association that deals with like bonds, commodities, Bitcoin, stuff like that. So essentially, you enter into an agreement to go into arbitration when you have a business or consumer relationship with someone. All right. So you have like your phone agreement, you have your, your cable bill or your whatever high-speed internet bill, whatever it is you have now. They always have an arbitration provision, and that says that if there's a dispute that arises from or related to the agreement, you go to arbitration. And then the arbitration forum is dictated where it says it's either AAA, it's NFA, it's JAMS, or it's, just general arbitration or whatever. So the difference between arbitration and litigation is that litigation goes through the courts. You pay the filing fee, you get into a court, you have a case, you have a lawsuit. You have a judge who makes, is impartial and makes determinations, conclusions of law, findings of fact. And eventually you'll go through the process and you'll have, possibility to settle, possibility to go to mediation. Otherwise you'll go to trial and you'll resolve the case on the merits and you'll have a judgment entered. Arbitration kind of works the same way. The whole concept behind arbitration is that historically speaking, and we'll get to why that's not necessarily the case anymore, historically speaking, it's been a quicker, more efficient way to resolve an adversary process rather than going to court. And so what it is instead of going to a public court, you go to a private venue, which is the arbitration. So you go before one of the panels, or if it's the state of Florida, you can go under the Florida Arbitration Act rules, or you can go under the Federal Arbitration Act rules. You select an arbitrator, and, the arbitrator could be an attorney. The arbitrator could be a former judge. The arbitrator could also be a mediator. And the arbitrator is the one who will decide the case. So then depending on the agency that you went through, they all have their own rules and their own processes and their own timelines and everything to set up the arbitration. So generally speaking, you file your arbitration claim, you get assigned a case manager, and then the case manager reaches out to the other side shows up with their attorney or without their attorney, and then you get a case management plan put in place that says what the schedule of your case is going to be, what's going to happen, what the timeline is, what the fees are, and then you pick out your arbitrator. So then you agree on an arbitrator. If you can't agree on an arbitrator, the company will appoint an arbitrator for you who's qualified in the arbitration area. And then you'll have like a preliminary conference with the arbitrator. The arbitrator will set out further deadlines, further things. We'll say if you're going to do discovery, so if you're going to send out written questions or requests for documents, if you're going to have depositions, they're going to require you to go to mediation probably, which we discussed in the last podcast. And they're going to set up your final arbitration, which can be on Zoom or in person. And they'll set up the schedule and be like, it's going to be 1, 2, 3, 4, 5, 2 weeks, whatever time it's going to be. And they set up their time frame. And then basically you go and you arbitrate the case. So then someone will file a response to your initial demand for arbitration, which is like you filed essentially a complaint. They're going to file an answer, a counterclaim, or whatever. You're going to go through the discovery process. You're going to have limited motion practice. Like you can seek summary disposition and other things in certain arbitration venues. Some not really. They don't really like that. Some do. So it depends on where you are. And then you eventually work up your case. You'll go to mediation to see if you can resolve it. And if not, then you have your arbitration in front of the arbitrator where you present your case, they present their case. It's very similar to going to court, but it's a lot looser. It's a lot more informal, a lot more time saving, not as many hoops to jump through, not as many formalities. And then at the end, the arbitrator will write an arbitration award, which is essentially the arbitration equivalent of a judgment that says that either the claimant, who is the plaintiff, or the respondent, who is the defendant, wins or loses. They talk all about the case. They find the facts. They make the conclusions of law, or vice versa. And that's it. So then the case is over and you have an arbitration award. So either the other side voluntarily agrees to comply with the arbitration award and pay you money or do what's ordered in the award, or not. And if the answer is or not, then you have to take the arbitration award and you have to go to court. You can either go to state or federal court, and you have to have the arbitration award confirmed by the court, who then converts the award into a final judgment that has the full force and effect as if the court did it themselves. And then you go execute or act upon that final judgment. So that's if the other side doesn't cooperate, doesn't pay, etc. And the thing with arbitration is that you have very limited appellate rights.
I was going to see that.
Yeah, very limited appellate rights, like very limited, versus a court case where you have, regular appellate rights. The process to confirm the arbitration award, very limited objections to it, other than like malfeasance, the arbitrator was crooked, like just crazy stuff like that. Otherwise, arbitration awards are pretty much confirmed and converted into judgments. And that's the arbitration process. Going back a little bit along the way, the arbitration process can get very expensive this day and age, particularly if you're using like the AAA JAMS or NAM, because you have to pay all kinds of fees. You have to pay the filing fee just to get in front of the arbitrator. You have to pay case management fees and things as you go along. And then you have to pay for the arbitrator's time. You have to pay for the case manager's time. You have to pay for the use of the platform, for the document management and things like that. And then obviously if you get sent to mediation, you have to pay for the mediator. So it used to be a cost saving measure. Now, not so much, because there's a lot of costs involved in arbitration. And also it used to be a time saving measure, because at least at the state court level, cases used to take a long time.
Yeah.
And I'll qualify that in a second. Federal court, not necessarily, because federal court moves very fast,
Yes,
as you know.
yes, they do.
You get a scheduling order, and essentially within 12 to 18 months, your case is over. Come hell or high water, the case is done.
Yeah.
So state court was very different. Okay, state court could take years. You have all these war stories and all these urban legends of cases taking 10 plus years, whatever. In Florida, where we are, since COVID hit, the Florida Supreme Court had a lot of time to reflect and contemplate on the state of Florida courts and what's going on. And they determined, you know what, we sure have a lot of cases where they're not moving, and there's sure a backlog of everything. And so over the last 5 years, culminating with the January 2025 amendments, the Florida Supreme Court totally amended the rules of civil procedure in Florida, where now, instead of these languishing cases or whatever, cases are either 6, 12, or 18 months, no exceptions.
Yeah.
Doesn't matter how complex it is, how many parties there are, what's going on or whatever, it's done in 6, 12, or 18 months, no continuances, no excuses, it's over.
Yeah.
So now that that's in place, I know, you litigate a lot of cases, I do too. It's been very challenging to keep up with that or whatever. But what it's done is it's also affected arbitration, because the whole point of arbitration was that you wanted to get out of the quagmire of being in litigation or whatever. And now litigation, not so much a quagmire at the state level, because if you're dragging your feet and you're going as slow as possible, you're still going to be done in 18 months. And arbitration, takes less than 18 months, but at the same time now, the financial incentive or the reasoning behind the arbitration isn't necessarily as strong as it once was. A lot of people are not voluntarily opting into arbitration when they don't have to, because the court system is so quick, and because you're not paying, other than your filing fee and obviously paying for your attorneys, which you also pay for your attorneys in the arbitration. You're not paying the arbitration fee. You're not paying the regulatory fees. You're not paying the administrative fees. You're not paying the fee for the hearing. You're not paying the fee for the mediator.
It's incredible. Yeah.
And so you're saving a lot of money. So arbitration is changing, and a lot of arbitration, or some arbitration now, is moving online. It's moving to like kind of a no fault kind of thing, where there's like one arbitrator, and there's some new companies that are popping up that are trying to streamline the process and make it even more streamlined and cheaper. But essentially that's arbitration in a nutshell. Again, changing the whole purpose, the mantra for arbitration is kind of not as strong as it was previously, due to the fact that cases are moving a lot quicker now, and the arbitration is getting a lot more expensive. So that's your overview of arbitration.
Yeah, thank you. What surprises me sometimes is when I talk to clients, and I do a lot of breach of contract disputes, as you know, and they have arbitration clauses there. And it's usually like the third, fourth, usually at the end, you have the dispute resolution. And I asked them, do you know what a AAA is? Do you know what arbitration is? It's no.
Mm-hmm.
And usually, and I'm like, okay, let me explain this to you. Why did you agree to this? They didn't know. They just signed it. So I caution, my listeners, when you look at any type of contract, pay attention to the dispute resolution section of that contract. There's nothing wrong with opting with an arbitration clause if that's what you want to do. That's fair. But it's wrong when you sign to be part of an arbitration as a dispute resolution and you do not know what it is.
Mm-hmm.
Because the default is state court or federal court, depending where you are. Okay. But if you sign an arbitration clause, especially when, I'm not going to mention names, but they're very expensive, and then you do not know what you're getting into when you come to us to enforce the contract or to defend it, the only option that we have is going into arbitration, and that's going to double or triple the expenses.
Correct.
Yeah.
Yeah. And a lot of people, just have, boilerplate contracts or stuff, or contracts they've been updated in years that just have an arbitration provision in them. And like you said, I know a lot of my clients have no idea what arbitration is or the costs and the burdens associated with it. They just have it in there. And I know historically, big companies, banks, credit card companies, positions of power in contract negotiations, they've opted for arbitration because it's kind of a way to try to exclude people from dispute resolution, because they're not going to go through the process and all stuff like that. Or if they do, they're going to have to pay a lot of money and do a lot of things. So, but for the average, small business or, regular business or whatever, arbitration may not be the best option for you, because as you pointed out, it's very expensive to get into arbitration. And essentially you're doing the same work of being in court, except you're paying for it. So instead of a free judge, you have a paid judge. Instead of a free court clerk in administration, you have a paid administrator or whatever. And at the same time too, at the end of the day, unless you have a party who's willing to pay you on the other side or comply with your arbitration award, you have a meaningless private piece of paper that you're going to have to take to court anyways to convert into a judgment. So you have to go to court anyways.
Regardless, yes.
So you could have just went there in the first place.
Yeah.
And that's why, arbitration's changing. Like I said, it's not as advantageous as it once was. And it's not as, the theories behind it aren't as valid as they once were, because the court system moves a lot quicker now.
Something I recently had an arbitration, and one of the things, and we were going back and forth, and there was a lot of objections to certain evidence that was presented. And I think the judge in this case, he happened to be a judge, said, you know what, an arbitration is different. We don't have to follow the rules that strictly in regard of evidence. Can you talk a little bit more about that?
Sure. So again, it totally depends on what arbitration forum you're in, because they all have their own rules or whatever. But they mostly follow, like their pattern after the Federal Arbitration Act or whatever arbitration act you're in the state, but they have their own internal rules. Yeah. So it's a lot looser and a lot, less strict. So for instance, for like evidence stuff, okay, unless there's some really inflammatory, totally biased stuff, arbitrators are allowed to consider whatever you want to throw at them as evidence, and they just weigh the evidence. And if it's
even as hearsay, for example.
Yeah, even if it's hearsay or whatever, it's allowed for the most part, and they just weigh the weight of the evidence. If it's hearsay, well, I'm not going to pay as much attention as if it's a live testimony or something like that, but I'm not going to totally exclude it, because that's one of the few areas of your appellate rights are, exclusion of evidence, things like that, arbitrator bias, things like that. So arbitrators try to protect their arbitration record by, unless it's really inflammatory or really, whatever, let it all in, and they, review the weight of it, and they'll give the credit that it deserves, and it'll be part of their well-reasoned arbitration award. And, that's one of the benefits, is that you don't have to worry about, going through all the hoops of doing like a business records hearsay exemption, where I have to ask you now 10 minutes of questions so we can talk about that piece of paper, versus here's the piece of paper, thank you, we can move on. Yeah. And that's one of the benefits of arbitration, is that you can just do that, as opposed to, what is this document? How do you recognize this document? Is this document kept in the ordinary course of business? Was it made by someone? No, it's just, here's the document. Okay, let's talk about it. Yeah. And that's one of the benefits of arbitration, is that we can just get to the heart of the matter, and the arbitrator just weighs it accordingly, which is, again, arbitration still has its benefits and it's still useful. That's one of them, is that you're allowed to present your case in a less formal fashion, and you're able to cut time out and just do things in a lot, looser fashion than if you were in court. Whereas, like I said, we're just taking 10 minutes to talk about that piece of paper. We can just talk about it right now. So that's one of the benefits of arbitration, is that the rules are, there's still rules. You still got to comply with it, and stuff can still be excluded, but it's a lot looser, and it all depends on what arbitration form you're in.
And in terms of going back to the cost, I mean, these organizations, the companies that manage arbitration claims, they're required to pay the judges in advance.
Correct.
It's not something that you go by the hour, you pay them as you go. The judge, the arbitrator, makes an estimate how much time it's going to take, and they want that deposit way in advance. Sometimes $10,000 or $20,000 that you got to put up front.
Correct.
Before the case even begins.
Correct.
That's not including your attorney's fees. So when you're looking at arbitration, people have to weigh whether or not that's worth it.
Correct. It's all upfront money, and they will dismiss your case unless you pay them in advance.
I was going to ask you, what happens if somebody cannot afford the arbitration?
Well, there's two options. Okay.
Yeah.
I've dealt with this as on the litigation side, and I've seen this from the arbitration side too. Okay. So depending on which arbitration form you're in, you pay your fees. Okay. And the other side has to pay their fees in order to participate. So guess what? They may not want to pay their fees. And guess what? If they don't pay their fees, you get kicked out of arbitration and the case gets dismissed. You get your money refunded less, less some costs, but you're out of arbitration. Or if you want, you can pay their fees. So they'll gladly arbitrate your case for you if you're the claimant, but you have to pay the respondent's fees and then, arbitrate the case. They may still participate, just not pay their fees. And then at the end of the case, you're entitled to recover you paying for their fees in addition to whatever else you're entitled to recover for. So I've dealt with that. I've dealt with, on the litigation side, that exact scenario where we got kicked out of arbitration because my client didn't want to front the fees. And so we went to court, and then they came into court and said, no, we want to go to arbitration. And so we said in court, here's the order of dismissal saying that they didn't want to arbitrate. And they're like, no, we do now. We elect our arbitration rights. We're going to pay this time. And so I dealt with that on 4 related cases where the state court judge ruled twice in my favor and twice in their favor. And they're all 4 on appeals now. So, to be told, but that's what happens is either if you don't pay, you get kicked out, or you can pay the other side's fee if you want to go forward. And then hopefully you collect it later on.
Matthew, this was very informative. I hope our listeners now have a better scope of arbitration, the cost, and the benefits or lack of thereof of arbitration. How do people find you, Matthew?
Sure, Rich. So, my website is the best way to find me, fornarolegal.com. It's got all my contact information, all my social media, all my blogs, all my white papers, all my videos. It's all on there. So I'm easy to find on social media. I'm easy to find on Google.
All right. And you'll have this Fornaro Legal's Fornaro legal.com.
Yep. Just my last name, legal.com.
Your link will be in our show notes as well for our listeners. So this is episode 139. Thank you, Matthew, again for joining us. It was very informative. Hope you come back.
Thank you, Rich. I'm glad to finally be here. I'll be back.
So I close the show. If you have any questions about any of these topics, my email is rich@richsierra.com. If you have a way to contact us, my number is 866-842-5202. If you want to check out my website is floridasmallbusinesslegalcenter.com. If you want to see the video of this podcast, we're at youtube.com/@RichardSierra. We're on Facebook and Instagram at FSB Legal. Again, check out my book, Business SOS, Economic Legal Mistakes, Business Owners Make and How to Avoid Them. It's available on Amazon, Barnes & Noble. You can ask for your local bookstores as well. Until next week, this is Rich Sierra. And remember that my goal is to help you succeed.